Good evening and welcome to the Ombudsman program. My name is Diane Welborn. I'm the Ombudsman and I'll be your host for the program this evening. Tonight we're going to bring you an hour's worth of information about power of attorney. I'd like to begin by introducing my guest tonight for the program who are going to help share this valuable information with you. First, I'd like to introduce Gary Weston, who is the Regional Managing Attorney for Legal Aid of Western Ohio. Thank you for being here tonight, Gary.
Good evening, Diane.
Appreciate it.
It's a pleasure to be here.
Thank you. And I also have with me Monica Wynn, who is the Long-Term Care Ombudsman Program Director in our office. So thank you, Monica, for coming on the program
Nice to
tonight.
be here, Diane.
Great. I want to start this evening by giving a little bit of background about why the Ombudsman's office became interested in developing this program and others on power of attorney. We receive a lot of calls at the Ombudsman's office from people who are serving as a power of attorney for a loved one and have many questions about what their responsibilities and duties are. Then we also have had a number of calls where people have suspected that the power of attorney that they had chosen had not actually executed the power of attorney in a way in which they should. So all of this led us to realize that we wanted to play a larger role in trying to educate individuals about the duties of a power of attorney, the responsibilities of a power of attorney, why we might need a power of attorney, and then lastly, for tonight's agenda, who might we choose to be our power of attorney. So I would like to acknowledge that we partnered with both Legal Aid of Western Ohio and Catholic Social Services of the Miami Valley to put together this presentation to provide this information and background. We're trying to reach as many seniors as we possibly can, and we're trying to reach as many adults who might one day be asked to serve as power of attorney as we possibly can. So that's rather our rationale for this program and developing this program. Is there anything that you all would like to add to that at this point?
Well, I think that this is a great topic to address, not only for the reasons that you've described, Diane, but because actually there's been a change in the law in Ohio this year. In March of 2012, Ohio adopted what is called the Uniform Power of Attorney Act. This is model legislation that has been developed by the Uniform Law Commission, which is now adopted in approximately a dozen states or so. And every state that adopts it may have their own particular revisions or provisions that they want to have in their state. But in general, it provides some really strong protections for both the principal, the person who gives somebody else authority with the power of attorney to act in their behalf, and it spells out what are the duties of the agent, and it presents some opportunities for going to court and remedies if there is an abuse or misuse of authority. And I think we'll be covering some of those topics this evening.
Yes, we will, and thank you for pointing that out, that this new uniform law came right at the time when we were also developing our concern and the need that we had to reach out to people. So we will come back and say a little bit more about that. What is a power of attorney and why do I need one? I think this will be a good time to put up our first slide, please. All right. What is a power of attorney and why do I need one? An agent or power of attorney is really an inexpensive and simple way to make arrangements for your financial decisions to be made when you are no longer able to do so. The power of attorney document gives a person of your choosing the legal authority to act on your behalf. That person becomes your agent. It used to be called a durable power of attorney. Now durable is presumed, and I know that Gary's going to come back and talk a little bit more about that in a minute. Having a power of attorney is not unlike giving your friend or relative an extra set of keys to your home. you still have a set of keys to your home, but now a friend or relative has a set as well, so that if you lose yours or you get locked out or some problem happens, you can receive an assistance with that problem. If we become incapacitated and are no longer able to make financial decisions, we have already set forth in this power of attorney the way that we want our affairs to be managed when we are no longer able to do them. That in that way, we know that our affairs are going to be carried on in the way that we would like them to be. And this is all spelled out in the document and provided to the agent who has agreed to serve as the power of attorney. In this way, the agent can enact our wishes without having to ask other people or consult other people, because the document will already tell them what we want to have done. For example, in my own family, there are certain traditions of giving gifts at holiday and birthday, and should I become incapacitated, I would want that in my document so that whoever is handling my financial affairs could continue that family tradition when I am no longer able to do so. In some ways, one can think of a power of attorney as a gift for your loved ones. The person is making decisions about what they want to have happen with their financial affairs when they're no longer able. So it is spelled out, it's done ahead of time, it's planned, and it makes it easier for the person who is going to be acting for that person to already know what their wishes are. A recent study by the AARP revealed to us that 45% of individuals who are 50 years old and older have designated a power of attorney, and 70% of individuals who are 70 and older have a power of attorney. A sizable group that is growing. I also want to take a few minutes just to let our viewers know what can happen if a person does not designate a power of attorney and have the information about how they want their financial affairs handled. If one does not have a power of attorney, then if one becomes incapacitated, the action there would be that the family would need to go to court. And because once the person's already incapacitated, then somebody has to carry on, and it will be a court that will be deciding who is handling your affairs. And when that happens, what was once a private family discussion and a private decision-making by an individual and their agent becomes a matter in court where fees have to be paid. We don't need that slide just yet, thank you. Where fees have to be paid, and another person will be making those types of decisions that can just be made within the family. So the court would have to appoint somebody to do this if we don't take action ourselves and make that decision. I do want to add a note of caution. In talking with audiences about this before, we have uncovered one of those common myths that sometimes exist in our society. Just because we have a spouse, it does not automatically mean that our spouse is our power of attorney. I just want to clarify that. We may even restate it again in the program because it does come up quite a bit. A power of attorney is also significantly different than having a joint bank account. Joint bank accounts can accomplish a lot of purposes, but it is not a power of attorney document and does not constitute a power of attorney. It is simply a joint bank account. And I also wanted to add that many people are familiar with a payee system. A payee system is one whereby another individual can receive funds and spend funds, but again, just because there is a payee, that does not make the payee automatically a power of attorney for that individual. One of the questions that comes up a lot to our office as well is, when does a power of attorney document take effect? And we wanted to clarify that it takes effect when the person signs the document, or it could take effect when the person states in the document that it's going to take effect. For example, a person might write in their power of attorney that they want it to take effect when they become 70 years old, and in that case, it would go into effect at that time. There's some other examples that I think we're going to come up in later in the program. It is effective when the document specifies that it is effective, and the person that's writing the document and choosing a person to serve as their power of attorney can describe those circumstances. I believe that if a situation goes to the point where a person does become incapacitated, then the new law, which Gary will describe a little bit later, has that determined by a licensed psychologist or a physician. So I think now we would like to put up the next slide, which is about the Uniform Power of Attorney Act. And Gary's going to speak with us a little bit about this new act here in Ohio.
Sure, I'd be happy to, Diane. And there's a reference there you see on the slide to ORC, that is the Ohio Revised Code. And the statutory section is 1337.22. That's where the law starts. So if anyone wants more detailed information, they can find the Ohio Revised Code online and read the entire law. And of course, if an individual needs legal advice, they should be talking with an attorney about how the law pertains to their individual situation. I want to start with one definition that is not on the slide, which is how the statute defines a power of attorney. And it's a writing or other record granting authority to an agent to act in place of the principal, whether or not it's called a power of attorney. And that is really very interesting, I think. Under this law, there is a suggested statutory form included in the statute that people can use and customize very nicely for their own situation. And we're going to talk in detail about that during the program. But they don't have to use that form, or they don't have to use any particular form, even writing on a sheet of paper. I give authority to my daughter Sally to pay my bills and sell my car sometime next year. That would be an example of a power of attorney that would be legally enforceable in a court of law. There are definitions, and if we could have that slide back up a moment, that might be helpful. The principal is the person who is giving the authority and executing the power of attorney. The agent is the person designated to actually exercise the authority and take care of the financial or other affairs that the principal has authorized them to do. Durable is an extremely important concept, and Diana's already talked about that. It means that there is continuing authority the agent will have even at and after the point that the principal becomes incapacitated. And this is really one of the great things potentially about a power of attorney. Any one of us at some point in our lives could become legally incapacitated and be unable to make decisions. And if we're able in advance to designate who's going to be making decisions for us and how is that going to work, that may very well make things easier at that point and avoid possibly the need to go to court for a guardianship or just a lot of confusion among family or loved ones about how are we going to get the financial and personal business accomplished. So with the new law, there is a presumption of durability, and what that means is if it does not say one way or another in the actual document, it is just presumed that the authority given to the agent will continue, even at the point and beyond when a person becomes incapacitated. There is a definition of incapacity in the statute, and I just want to kind of quickly read that. It's not very lengthy. Incapacity means inability of an individual to manage property or business affairs for either of the following reasons. First, the individual has an impairment in the ability to receive and evaluate information or make or communicate decisions even with the use of technological assistance. or second of all, the individual is missing, detained, or outside of the United States. And that's just a brief summary of what the statute says. The principal in the power of attorney can actually specify how and by whom incapacity is going to be determined. And that might be something somebody wants to say, that incapacity will occur when my doctor certifies it or 3 of my family members. But if that's not included, then it would be either a licensed, well, a doctor, a medical doctor, or a licensed psychologist would have to attest to that. Well,
This adds the licensed psychologist. This new law, doesn't
Yes.
that add the psychologist into the picture
Yes,
there?
I believe that's new. One of the other things that I think is important, and you've, Diane, analogized to giving a set of keys, and I think that gets to something that maybe is at times misunderstood by individuals about powers of attorney. Just because someone grants authority to an agent or agents to take care of one's business or make decisions, it doesn't mean that the principal has given up that authority. The principal, him or herself, may continue to take care of personal and financial business, make decisions. The usual reason for giving authority to somebody else is because maybe the principal is at the point they really don't have the time or they need some help with that. And of course, it's a good thing to have in the case of incapacity. The law also provides that one can designate just not one agent, but if you wanted to designate a couple agents, maybe a son and a daughter, for example, you could do that. A practical issue with that, however, might be who exactly is going to make what decisions, and what if there's a disagreement among the agents. It would be good to have a clear understanding by everybody. How's that going to work ahead of time?
I just wanted to add in that a number of the calls to our office have been actually kind of about that point, that once a person has a power of attorney, at times we've had people contact us and say, I have a power of attorney, can I still look at my own bank statements? Can I still exert my own financial capacity when I want to? And of course, that's what you're saying with that part, that absolutely the person retains that ability and can do that.
Yeah. I was also thinking, Gary, when you were talking about the family dynamic in the case of having 2 people being issued different authorities as an agent. In the situation where you might not have executed a power of attorney document, and Diane, you were talking about having to go to court. Sometimes in the court system, if the 2 siblings or family is arguing about the situation, the judge can say neither of you will have authority. So again, a good reason to, one, have these conversations up front while still possible among the family is that if the case that you don't have this document signed, a judge may be making the decision that an independent party will be executing your financial affairs. And I think we all want somebody that we know and trust and have already executed and given that authority to on our own behalf.
And I did want to go back a moment to the really basic point here, that it's really important for the principal as well as the agent as well as others to understand that the assets, the property, the decisions for the principal really remain the principal's decision, and the power of attorney, both in terms of the specific provisions, in terms of who the agent is going to be that's selected, should be done with an eye to possible advantages but also disadvantages of having a power of attorney. And unfortunately, one of the disadvantages can be, and I think we have seen instances of this, is someone is granted authority who the principal really felt they could trust, and yet months later or years later learned assets were taken, property was transferred, sold, things that never were contemplated as even possibilities. So some of the opportunities in the law include not only picking a good, strong agent who is trustworthy and has the skills and ability to carry out the responsibilities, but also to customize the power of attorney document in a way that there will be, if you will, some checks and balances, reports, monitoring, whether the principal, him or herself, are going to be looking at the monthly bank statements, are going to be getting quarterly reports, are going to be having regular conversations with the agent about what's happening with my car, what's happening with my bills. Again, thinking about these things ahead of time can prevent some unpleasant surprises later on. And I think there are also some guarantees in the law.
And that could take place in a form whereby a person might designate a child to be their agent, but then also designate that quarterly the records be reviewed by yet another family member. That
Yes.
type of check and balance.
Sure, that might be a very good approach to it. I did want to talk a little bit more about what an agent does or potentially could do under the law, and it can range from a very specific, one-time, limited function that's specified. I'm appointing so-and-so to be my agent to sell my car or my house, or just pay bills while I'm on vacation this next summer, or whatever it may be, to a very broad grant of authority to take care of just about any financial or personal affairs of the individual. And one of the things with the new statute is that, and we'll talk about the form a little bit later, there's an opportunity for someone to pretty much check subject matter that they want the agent to have authority to handle: real property, personal property, stocks, etc. Or they can handle everything, or they can make it, through some special instructions, extremely limited. And again, I think it's a great practice for the principal and then for the agent as well to be in on the discussion, to be on the same page with respect to the scope of the authority, so there are no surprises later on. But it could be everything from just handling the checking account to paying particular bills to whatever really meets the need of that individual. And the more one can customize it to the needs, thinking about risks, thinking about advantages, the better off it is going to work. Now, there are some duties, and I think we have a slide about the scope of authority of the agent. There are some, and actually it's this slide that I neglected to speak to just talks about the principal makes a decision of which authority is the agent going to have: take care of expenses or receive benefits, deal with your bank, etc. But on the next slide, some of the mandatory duties of the agent are specified in the statute. Every agent has to act in accord with the principal's reasonable expectations, to the extent those are actually known, and in the principal's best interest if you don't know. If the principal hadn't said how they wanted a specific thing handled, and say the person became incapacitated and were not able to instruct or give further details, then the agent has to work in the best interest. And there is a fiduciary relationship, meaning the agent needs to proceed with loyalty, with trust, in good faith, honesty, working in the best interests of the principal. They have to stay within the scope of authority. If they've been given authority to handle paying the bills in the summer while the principal is on vacation, and they go to the local bank and say, I'm the agent under the POA, I have authority to take all the money out of the accounts and go buy myself that boat I've had my eye on, well, that certainly exceeds authority and probably violates some other important rules as well. There are some powers or some authority that the agent has under the law unless they are otherwise provided for in the power of attorney. One of those is to not create a conflict of interest impairing the ability to act in the principal's interest. sometimes the agent under a POA is going to be a family member, and there may be a conflict of interest situation there, and it does not mean that it is never possible for the agent to be doing something that also may benefit him or her, but there has to be great care taken in that, and inappropriate self-dealing and things of that sort would not be permissible, and that's something that could end up going to court or otherwise getting remedied, hopefully.
I was just thinking that an example of that might be that it might be a family business. So mother, father, and some children are owners in this family business, and yet one of the siblings or one of the children are now asked to be the agent of power of attorney. So here's a situation in which there may be a conflict of interest because that agent might be doing or acting on behalf of the principal that might eventually appear to be self-serving in that business decision-making, a family business, small family business kind of situation. So I think we keep going back to it's important to have these conversations, to have this be an open discussion, and this is one situation in which you want to make sure that you would have that discussion so that there isn't this appearance of taking advantage.
Right.
Well, the flexibility of this document now enables a check and balance to be put into that, in that kind of family business situation, and in many others.
Right. I also wanted to say that there are some things in the statute that the agent definitely cannot do or does not have authority to do unless expressly provided for. And these, in general, are things that could potentially remove assets or jeopardize the estate plan of the principal. And those include, by way of example, creating, amending, revoking, or terminating an inter vivos trust, which is a trust created during the lifetime of the principal, making a gift, creating or changing rights of survivorship, creating or changing beneficiary designation, and there are other things specifically listed. But again, the general idea is that because there would be a great risk of depleting assets from the principal who needs those or wants those, deserves those later in life, the agent just cannot go ahead and do unless there's explicit authority for that under the law.
Diane, you had mentioned about wanting, the family tradition of giving gifts at Christmas and at birthdays. That would be one of those specific instructions in this document.
Yes.
That would
Yes,
an
and
example.
I also wanted to point out that we're not going to go in this evening because of the amount of time we have available, but there are some very specific limitations in terms of the amount of gifts that might be made by the agent, and that should not only be specified for the POA, but it's something that, especially if someone has significant assets, they should be consulting with their attorney, their financial advisors, or whoever else to understand the interrelationship of some of those complex issues.
All right. I think that there are a couple of things also that a power of attorney really just does not do. We were kind of moving toward that, and I think there are a few key things that we want to make sure our viewers know about that power of attorney does not do. Would you like to take that?
Well, there is something so personal
Yes.
that I think the law has generally realized this is not something that should be delegable to somebody else, like getting married,
Yes.
voting. You can't give authority to an agent to go to the voting polls this November and cast a ballot for you.
Or adopt a child.
Correct.
Yes, those types of things. There's certain things that are definitely written in.
I think it's a good moment just to bring up one of the things that an agent for power of attorney for finance also cannot do is make healthcare decisions. This is not a healthcare power of attorney. So though there are some provisions in which the two need to work together, this is also an area in which they do not have authority to make health decisions.
That is a great point, Monica. And while sometimes the power of attorney we're talking about this evening is called a financial power of attorney or a durable power of attorney or a durable healthcare power of attorney or even other names, it definitely is distinct from the healthcare power of attorney or any of the healthcare advance directives. And while there are some provisions in the law that the agent under the financial power of attorney should be consulting with whoever has the healthcare power of attorney and vice versa, there are distinct responsibilities regarding the two.
Yes. And we're not covering the healthcare power of attorney in this short program. That'll have to be reserved for the future. So,
All right.
all right.
Well, I think this is the next opportunity to talk about what actually you need. What's the paperwork? So there's another slide we have about what paperwork is needed. And really, as Gary had talked about, it's a very simple form. The Ohio Revised Code has created this form, so you can actually initial and check marks that will direct certain responsibilities, such as sell your real estate or handle your bank account, or to sell and work with your financial institutions and trusts and stocks and bonds, et cetera. And it is very prescribed, this document. And it's good that way because it kind of covers all of the areas that might be necessary. So completing the form is the first part. And really, we want to also make sure that there is room for special instructions and to write those in to make sure that you are letting people know what your special instructions are. Gary, you in the past, you've used an example of I have a special tendency, not yourself, but to purchase, I don't know this, but to purchase lottery tickets. I'm always, that's a part of my life, and I would like that to continue on in if I am no longer able to get to and do that myself. So special instructions, don't forget those. Once it's completed, though it's not necessary under the law, we do recommend, because this is a very powerful document and we want it to be very strong, is to have it witnessed by two independent individuals and to also have it notarized in front of these witnesses. This gives us and it gives anybody who's accepting this document and is taking action, such as your bank, that this has been well considered, that people have witnessed you doing this. It does not appear that you are doing this under any duress, and these are your wishes and actions to be taken. So.
And Monica, if I could just add to that, as you mentioned, it's not required. You could have a power of attorney that's just written on a piece of paper, signed by the principal, that could be enforced. The problem is, at a later point, maybe at a point when the principal can't explain what he or she had in mind, and there may be controversy about that, it's going to be difficult proving this was actually the wishes of the principal. So in the statute that is currently the law in Ohio, there is a presumption that it's genuine if it's been notarized. It doesn't even have to be witnessed for that presumption. So it's just a very sound practice to get it notarized. I do think another reason to consider getting the two witnesses as well as it being notarized is the fact that the law on powers of attorney may vary in other jurisdictions across the country. So if there were an issue in another jurisdiction and the issue had to be litigated, for example, that would be just another layer suggesting authenticity of the document.
Mm-hmm. Just want to also point out that there are certain agencies or entities that will not accept this document because they have their own. So one example is the Social Security Administration. They have their own. So viewers should just be aware of that as well, that they may yet need to fill out another piece of paperwork, but that doesn't mean that we are in any way suggesting people don't do this.
No.
And there may be banks or particular financial institutions who have their own forms and will want that form. So I think it's a great practical point to talk with the individuals and organizations that need to know what the provisions of the power of attorney are going to be to ensure that whatever paperwork is needed will be in the hands, and they'll give, they'll give effect to that.
Right.
And one other place, we were talking about ability to sell property, our real estate. It is recommended that that document be given to the recorder's office in the county in which the home belongs. Because in order to sell property, if I have lost capacity as the principal and there's a house to be sold, then my agent and the recorder's office needs to know that I have given authority in advance to take that action. So very simple form, completing it, having it signed, notarized, and informing individuals and institutions of your wishes. And that kind of leads me to, who do I tell? I mean, once I've got this and I've done this, then you are going to want to, one, give the document to the agent that you have assigned the duties to. They need to have a copy of that. Maybe family members also might need to have a copy of that so that they know what responsibilities have been given to somebody else. Possibly your bank, so that they are aware in advance. Not only, Gary, you had talked about when I go away on vacation, that it's good from this time to this time. Your bank is going to, and if there is any activity in your account while you're away, your bank is going to want to possibly know that this person is authorized to carry out these duties. So again, you're going to want to be sending it to individuals, and we want you to keep track of who you inform and who you give this document to. Because in addition to being able to give this, and Diane used a gift, giving this gift of information and authority, you can also take it back or revoke that gift. And in revoking that gift, in the Ohio Revised Code, there is a form letter that kind of will help very easily state. Is it in there?
It's not in the code, Monica.
I thought so. Yeah.
There are some forms I know we've made available in some of our prior presentations, but I think the important thing is in writing, somehow, the person indicates they are revoking the previous power of attorney, and as you said, getting it in the hands of anybody who may have been relying upon the earlier power of attorney, because I do think the other thing the law provides is, say you've given a copy of a power of attorney to your bank and they're relying upon your agent having authority. If you go ahead and revoke that authority unbeknownst to them and the agent comes in and is transacting business, well, that's likely to be enforced because it appears that the authority still continues. So if you somehow in writing do the revocation and distribute it widely, that's the best bet.
Right.
And there are some forms that make that very easy. Yeah.
And as simple as the form can be, as Gary, you were talking about, you can simply handwrite that. You can also simply handwrite that I am now revoking or taking back your authority as my agent for power of attorney. And also, you want to make sure that if I am revoking a power of attorney, that I'm also giving that former agent, that now ex-agent, a copy of that letter so that they know I've revoked it. Not just the financial institutions or whoever I've given it to, but also to make aware that I am revoking your authority at this time.
So the person can change their mind. If it turns out that the agent that they've chosen, for whatever reason, doesn't work out or moves too far away or whatever, it's easily changeable.
Yeah. And that perfectly to when does that power of attorney end? And very, very clearly, the power of attorney ends upon the death of the principal. So the authority to take any financial actions, to sell property, to do any of the things that are listed in that power of attorney document end upon the principal's death.
And this is a question that we get, sometimes another kind of maybe general misunderstood point there, that the power of attorney document is not a will, and the power of attorney cannot go and act beyond when the person is deceased. So.
Somebody upon the death is then taken authority or direction from a person's will, last will and testament. So again, that ends then. The agent, the power of attorney and the agent's authority may end when the duty is completed. If I have given a certain specific period of time in which I am going to be away and I'm giving that authority, it starts this date, it ends this date, it ends on that date. Or when I am giving the authority to sell a house. The house has now been sold, all things have been executed, it comes to its end. It can also end if the court, the court determines that it needs to come to an end. And we will talk a little bit more about some of the provisions when we've touched on when things go wrong, okay? And that there is the checks and balances within the law that gives the court some authority to make determination of whether the agent was acting in the best interest of the principal and can revoke their authority themselves. One interesting thing why it can end is that, say that I have given my spouse my authority to be my agent of power of attorney, and my spouse decides to get a divorce, files for divorce or dissolution or an annulment of our marriage. At that point, it also ends. So, because there could be some disadvantages to having my spouse who now wants to divorce me to take care of my finances.
Right.
Although I think the principal could specifically include something in the power of attorney that the agent would continue even in a divorce situation, but typically I don't think that's going to be occurring.
And I think that one thing a person can do is to designate not only an agent, but then a backup agent or a successor agent, so that if the first agent is revoked for any reason, then the second agent may come into play.
Right. And one of the other instances where the power of attorney authority comes to an end is when the original agent is no longer able to act. He
Right.
or she dies, becomes incapacitated, drops out of sight, and having a successor agent in that situation is a good backup plan.
And that successor agent is one of those designations you make on that original form that
Yes.
you're filling out.
Right.
And certainly would want to have that in there. One of the things that we want to talk about, because we have talked a little bit about when things go wrong, when the agent is acting not in the best interest, and we certainly have had occasions where that has happened. There is the ability to make special instructions for checks and balances. We talked briefly about those that would include, I will continue to get a monthly statement of my financial affairs as the principal when you are now having action taken on my behalf. I might give the authority for a balance on a monthly basis to independent accountant. I might have my aunt and uncle review what you've been doing. And certainly I would want to have receipts and keep records, so I can designate all of the checks and balances that I want and personalize that to my need. But in the law itself, there's a provision of checks and balances. And I think that's an important item to talk about, because oftentimes we don't think about that our family member might be doing something in the future that we would not even imagine, like you said, not contemplate that they might take advantage of their authority. And so the court and the law has given the court authority to make that determination. And there are a host of individuals that can bring that concern before the court, including the principal themselves. I get a feeling that something's not right. I'm the principal. I am going to ask the court to review the actions of the agent. Another person that might be bringing that forward is the power of attorney for health care. Those two individuals will have to work together. In so many situations, the cost of maybe, let's just say, long-term care goes hand in hand with the decisions that a healthcare power of attorney is going to make. So they need to work together. And at that point, if the healthcare power of attorney were to have some some questions, they too would be able to bring that before the court. Other government agency, maybe there is a suspicion of abuse, and the Adult Protective Services perhaps would want to have the review of the agent's actions taken before the court. So it is important that if you have not specified a check and balance, that there is one embedded in the law itself. I would say, just as an example, we may not ever think about somebody doing something and taking advantage of us. And this happened to somebody who we have worked with, and over years of time, small things and then larger things, to over $100,000 of missing assets for an individual. And the money is not there to be returned. The harm has been done. The senior doesn't have the ability to re-earn those monies. So checks and balances inside the law is great, but really write them, make them special instructions. I think that's really important, that we just give that some consideration.
I think that's very important based on the kind of calls and questions that we've had throughout this process, that whatever one can build into that document, the power of attorney by way of checks and balances, is very important.
And Monica, if I could just say a little bit more about the legal protections. As you've mentioned, with the new law, there is now standing for a very long list of interested individuals to get into court, to ask a court to construe the power of attorney or review the agent's conduct and grant appropriate relief and such, including the principal, him or herself, and the person who has the healthcare power of attorney, and many, many other interested parties. And the court has really broad authority to remedy any misuse of authority, including ordering repayment of funds improperly taken, or that the agent didn't have authority to deal with, et cetera, et cetera. But as you have both mentioned, the practical issue is if those assets are gone, if the property no longer exists, it may be practically too late. So developing the power of attorney the right way, picking someone who you trust in, I know you're going to talk a little bit more about that, and monitoring really closely to see what is the agent doing? What's happening with my assets? What's happening with my property? Do I have any questions? I want to get an answer to those questions in a full and timely way. And if I'm not happy with the answer, that would be the time to potentially change the power of attorney, pick a new agent, put better controls in place, or whatever it is. Prevention is worth an ounce of prevention is worth I think that was Benjamin Franklin, the pound of cure, and that's certainly true in the power of attorney context as well as other arenas.
Good.
I was thinking briefly about when you write these special instructions. If I am going to give authority for my agent to be paid something, it needs to be in there so that nobody presumes that I am doing as an agent something that I wasn't given authority to do. So an agent may be reimbursing themselves for expenses that they've incurred in doing and carrying out these responsibilities. But if I really should make those special instructions.
Yeah. Now, if you do not specify that the agent is going to be paid and how much, the law does provide that the agent is entitled to reasonable reimbursement and compensation. And if it came to it, that is something that a court might have to determine what was reasonable. But if you want to be very specific about that, better to include the details and be sure that you and the agent and others involved are on the same page with respect to how that is going to work. And I might also mention that the law does provide much authority for the agent to be doing a wide range of things as your agent. If you give him or her authority to handle real property transactions, personal property, et cetera, there will be many standard functions that the agent will have authority to take care of that's provided by the law. It might be engaging in litigation. It might be hiring some other experts, a financial advisor or an attorney or someone to handle particular tasks. And again, that depends in large part on how significant the assets are. Do you have a lot of property that needs fairly complex attention because you need to ensure that's done the right way?
I think that that's really important to stress that, because if the agent is going to be reimbursed for the work of being an agent, if it's written in the document what that reimbursement is, then other family members who may not understand fully what's going on, it can eliminate a lot of conflict if it's all written out and if it's all predetermined. And then if somebody does have a question about it, it's there in the document.
I think this kind of leads us to who might you choose, because we were talking briefly about the authorities that they're given, and so we want to kind of look at who should I choose as my agent. And first and foremost, the first thing that came to all of our minds was someone I can trust. Absolutely, I have a good communication with, that someone who is honest. In the law, they have to be loyal. But when I'm making that, I might not be thinking of the law, but I'm thinking about somebody who is trustworthy, who is honest, someone who understands that this might be a volunteer job. Though there may be reimbursements, but this is a responsibility that may go beyond what their everyday transactions and small banking responsibilities may be. In the future, it may be that I need to enlist the help of a real estate agent to sell a house, or I might need in the future the help of a tax accountant or somebody to do taxes. So what might start small may also be a little bit bigger than that. And we talked.
Yeah, I just think we want to, of course, somebody that we can trust and somebody that's going to act in our best interest. But I think we want to make the point clearly too that this person doesn't have to be an expert in everything. So they can go to a tax preparer, they can go to an accountant, they can go where they need to get those skills. Yeah.
Absolutely. That's again, we don't have to have all the skills ourselves. We sometimes just need to know and choose an agent that knows when to ask for help. Because we're not experts in everything, and we're asking, so a good person to communicate, someone who will ask for help when it's needed, and to be responsible and reliable in carrying out this document, and what's written in this document is really the key here. And good communication, we kept going back to it among family and in the document itself to really communicate your wishes.
Right. And I think we have had the question on occasion about, well, who can I choose? Some people may feel as if there's not somebody immediately present in their life that they can choose. So maybe we want to let people know that it doesn't have to be a relative. It can be a long-term neighbor. It can be a good friend from church. There's more examples than I have time to give tonight, but just wanted to point that out. And it can be any of those people, even if one does have children. You may want somebody else to do this.
And Diane, speaking of time, it might be good before our time runs out this evening just to say a little bit more about the form, the statutory form, and some other ways to get a form completed for a power of attorney. And as I believe was mentioned earlier, in the new statute, there is actually an optional form. And the nice thing about this is it's very user-friendly. Someone could go to the Ohio Revised Code, and we're also going to give a website. I think we might have that on a slide.
It's on the very last slide, so we can go ahead and put that up for a minute.
And that is through Pro Seniors, which is a statewide organization that helps older individuals. But you can actually get on a website and answer some questions, and produce the document, assuming you have a computer and a printer and a little bit of know-how, and actually produce this yourself. Now, there may be times when it would be very important to consult with an attorney for legal advice about your individual situation. But the statutory form is in the law, so people can do it themselves if they decide to do that. And one of the nice things about this form it has some introductory sections with important information about what is a power of attorney, what are the duties of an agent. Many of the things we have talked about this evening, but it's in writing as kind of reminders for someone who is filling out the form. It talks about what are mandatory duties, and then there are fill-in-the-blanks to put, this is a person I want as my agent. If you want to name a co-agent, if you want to have a successor agent, you put their contact information and such. You designate whether it's a general grant of authority or you just want them to handle specific things and initial that. There is a special instruction section. We've been talking about protections you can write in. You can even nominate a guardian if you want to. And then it's signed, it's notarized. There is even a section with important information for the agent. It's a very user-friendly form, and we want folks to know that exists.
Yeah, that's very important. Thank you very much. I'd like to ask if the last slide could just be put up again. It has contact information for both the Ombudsman's Office and Legal Aid of Western Ohio. At the bottom, it also has the Pro Seniors web address. But we also want to offer to the viewers that if people are unfamiliar or don't have the ability to go get the form themselves, either don't have a computer or don't know how to find it on there, you can certainly call the Ombudsman's Office and we'll be happy to provide that kind of direction and assistance so you can have access to the form. I also wanted to say before we're out of time that if you already have a power of attorney document, you might need to review it in light of what we've presented tonight, but it's not as if you have to go and develop a new one. So I'd like to thank both Gary and Monica for being on the program tonight and providing all of this interesting information, and thank you to the viewers.